At-will employment is the default rule in most states across the United States, and it plays a central role in determining whether an employer can cut an employee's hours without warning. Under this doctrine, either the employer or the employee can end the working relationship at any time, with or without cause, as long as the reason is not illegal. The same flexibility applies to scheduling. Employers generally have the right to adjust hours, reduce shifts, or change schedules whenever they see fit, and workers often discover that the law does not guarantee them a certain number of hours unless they are covered by a specific contract or collective bargaining agreement. This reality can be frustrating for employees who rely on stable schedules to plan their finances and daily lives. A worker may feel blindsided when they show up expecting a full schedule only to find their hours reduced dramatically. Yet under at-will rules, there is usually little legal recourse unless the employer's decision violates another protection, such as cutting hours only for employees of a certain race, gender, or religion, or retaliating against someone who filed a complaint or requested leave under a protected policy. Without such unlawful motives, the employer's right to change scheduling remains intact. Unionized employees or those with employment contracts are in a different position. Collective bargaining agreements often include clauses about minimum hours, notice requirements for schedule changes, or protections against arbitrary cuts. In those cases, workers can hold their employer accountable through grievance procedures or legal action if schedules are changed without following agreed-upon terms. For non-union workers, however, the flexibility built into at-will employment tends to favor employers, leaving employees with less predictability and control over their work schedules than they might assume. While at-will employment gives employers wide latitude to reduce hours, wage and hour laws set important boundaries that cannot be crossed. The Fair Labor Standards Act, commonly known as the FLSA, establishes minimum wage and overtime protections that apply regardless of schedule changes. If an employer cuts an employee's hours but then pressures them to work off the clock, refuses to pay for all hours worked, or reduces shifts in a way that drives pay below the federal minimum wage, that would be a violation of federal law. Similarly, if employees are scheduled fewer hours but are then asked to stay late without proper overtime pay, the employer could face significant penalties. Another key issue involves misclassification. Some employers attempt to label workers as independent contractors or as exempt from overtime rules in order to avoid paying full wages when hours are shifted. These practices often intersect with schedule changes, leaving workers confused about their actual rights. The law is clear that classification must be based on job duties and not on employer preference, so cutting hours while simultaneously misclassifying employees can quickly turn into unlawful wage theft. State wage and hour laws often go further than federal rules, offering stronger protections. Some states require reporting time pay, meaning if a worker shows up for a scheduled shift but is sent home early, they are entitled to partial compensation. Others impose penalties on employers who fail to keep accurate records of hours worked, making it harder for businesses to quietly reduce schedules while avoiding wage obligations. These safeguards exist to ensure that hour cuts cannot be used as a loophole to deprive workers of fair pay. Employers who ignore these requirements risk not only legal action but also significant financial consequences. Some states and cities have gone beyond federal law by adopting predictive scheduling or fair workweek laws that directly address the issue of sudden hour cuts. These laws are especially common in industries like retail, hospitality, and food service, where workers often deal with unpredictable shifts. Under these rules, employers are required to provide advance notice of schedules, often ranging from 7 to 14 days. If an employer cancels or reduces a shift without sufficient notice, they may be required to pay the worker for part of the lost hours as compensation. This framework is designed to give employees more stability in their incomes and personal planning, acknowledging that unpredictability has real financial and emotional consequences. For example, cities like New York, San Francisco, and Seattle have adopted fair scheduling laws that require employers to give workers predictable schedules and to pay a penalty when those schedules are changed at the last minute. Some states have passed similar laws, focusing on industries where erratic scheduling is most common. These laws often also prohibit practices like clopening, where employees are scheduled to close a store late at night and then reopen it early the next morning, leaving little time for rest. The goal of predictive scheduling is not to eliminate flexibility entirely but to balance the needs of businesses with the rights of employees to plan their lives. By requiring notice and compensation, these laws discourage employers from treating workers' hours as expendable and push them toward more thoughtful scheduling practices. While not all states have adopted these protections, the trend is growing, and many advocates see it as a necessary step toward fairer treatment for hourly employees who too often bear the brunt of unstable scheduling practices. Even though employers generally have the right to reduce hours, the law draws a clear line when those cuts are made for illegal reasons. Federal employment protections prohibit employers from targeting workers for hour reductions based on discrimination tied to race, color, sex, religion, national origin, age, disability, or other protected categories. For example, if a manager systematically cuts the hours of female employees while leaving male employees unaffected, that could amount to gender discrimination. Similarly, reducing hours for workers of a particular racial or religious group while treating others more favorably would likely be considered unlawful. These protections ensure that hour adjustments cannot be used as a cover for discriminatory practices. Retaliation is another key area where employers may run into legal trouble. If an employee reports unsafe working conditions, files a wage complaint, requests family or medical leave, or participates in a discrimination investigation, the employer cannot punish them by slashing their hours. Retaliation laws are designed to protect employees who assert their rights from facing negative consequences. Hour cuts in response to lawful actions like whistleblowing or union organizing are therefore not only unfair but also illegal under federal law. In addition, laws such as the Family and Medical Leave Act and the Americans with Disabilities Act provide additional layers of protection. Cutting hours to discourage employees from using protected leave, or to push out workers with disabilities who request reasonable accommodations, would violate these statutes. While employers may argue that operational needs justify schedule changes, courts and regulatory agencies closely scrutinize patterns that suggest an unlawful motive. This means that while sudden hour reductions are often legal, they cannot be used as a tool to discriminate, retaliate, or undermine the legal rights of employees who are protected by federal or state employment laws. Sudden reductions in work hours can have a profound impact on employees' financial stability and overall well-being. For many workers, especially those earning hourly wages or living paycheck to paycheck, each shift represents a critical portion of their monthly income. A last-minute cut in hours can disrupt the ability to pay bills, afford groceries, or cover transportation costs, creating immediate financial stress. Beyond the paycheck itself, reduced hours can also affect eligibility for benefits like health insurance, retirement contributions, or paid time off, which are often tied to the number of hours worked. This ripple effect shows that hour cuts are not just an inconvenience, they can carry serious consequences for workers' economic security. The unpredictability of scheduling can also take a toll on personal life and mental health. Employees may struggle to coordinate childcare, schooling, or other responsibilities when their hours fluctuate unexpectedly. Inconsistent schedules make planning daily routines difficult, and the anxiety over potential cuts can affect concentration, morale, and job satisfaction. For employees who rely on multiple jobs to make ends meet, the sudden loss of hours in one position can create cascading challenges across all aspects of their lives. For communities and economies, widespread unpredictable scheduling can have broader consequences as well. When workers' income fluctuates unexpectedly, consumer spending may decline, and financial instability can increase reliance on public assistance programs. This demonstrates that the issue is not just personal but systemic, highlighting why some cities and states have enacted predictive scheduling laws. By recognizing the impact of sudden hour reductions, policymakers aim to provide workers with greater financial security and stability, acknowledging that fair and predictable scheduling is an essential component of modern labor rights. Even when reducing hours is legally permissible, how employers handle the situation can make a significant difference in workplace morale, trust, and overall productivity. Open communication is one of the most important practices for minimizing the negative impact of schedule changes. Employers who inform employees as early as possible about potential reductions, explain the reasons behind the decision, and provide guidance on how it will affect pay and benefits demonstrate transparency and respect. This approach helps employees feel valued and reduces the perception that management is arbitrary or uncaring. Consistency is another critical factor. When reductions in hours appear random or target specific individuals without clear justification, it can create tension and resentment among staff. Establishing a fair and predictable process for making scheduling decisions even when cuts are unavoidable can reduce conflict and prevent misunderstandings. Written policies outlining how hours may be adjusted, along with clear criteria for prioritizing shifts, provide employees with a sense of structure and fairness. Employers can also take proactive steps to mitigate the impact of hour reductions. Offering alternative shifts, flexible scheduling options, or temporary assignments can help maintain employee income and engagement. In addition, management training on the legal and ethical considerations of scheduling decisions ensures that supervisors handle reductions appropriately and avoid practices that could lead to discrimination or retaliation claims. Ultimately, even though the law may allow sudden hour cuts in many cases, how an employer approaches the situation influences workplace culture and employee retention. Businesses that prioritize transparency, fairness, and empathy are more likely to maintain trust and loyalty among their workforce. By treating scheduling decisions with care and respect, employers can reduce the financial and emotional burden on employees while safeguarding the company's reputation and legal compliance. This approach benefits both workers and employers by creating a more stable, predictable, and respectful work environment. While the law often allows employers to adjust hours, understanding your rights and knowing what protections exist is essential. Open communication, fairness, and legal awareness can help employees navigate sudden changes without losing trust or stability. At the end of the day, respecting both the law and the people who make the workplace function is the key to a fair and sustainable work environment.